Hello, everyone. Thank you for joining our town hall this morning. My name is Anna Lee, and I work at Vermont Legal Aid in the Office of the Healthcare Advocate. Vermont Legal Aid is a nonprofit law firm that provides civil legal aid. Civil legal issues include things like housing, healthcare, disability law, and senior law. You can find more information on our joint website with Legal Services Vermont, www.vtlawhelp.org. Thank you for joining us today. Our town hall includes guests, and you'll be able to ask questions of our guests. If you're joining us on Zoom, you can click on the Q&A button in Zoom, where you can type in your questions, and I will ask out loud. You will also get a written answer to your question from our moderators. If you are joining us on Facebook Live, you can type questions into the Facebook Live comments, and I will read those out loud as well. You will also get a written response on Facebook from the moderators after the town hall. If you are calling in or listening over the phone, we don't have a way for you to ask questions from the phone during the live stream, but you can always call Vermont Legal Aid at 1-800-889-2047 to speak with a Vermont Legal Aid or Legal Services Vermont attorney or paralegal for confidential help. And you can also find answers on our website, vtlawhelp.org. Today we're going to be talking about state and federal fair housing protections. We have Christina Nolan and Jules Torty from the U.S. Attorney's Office, as well as Erica Johnson from Vermont Legal Aid. Jules and Christina, thank you for joining us. Could you introduce yourselves and your office for us today?
Hi, my name is Jules Torty, and I'm the Civil Chief and Civil Rights Coordinator at the U.S. Attorney's Office here in Vermont. So I'm the office's point of contact for civil rights issues.
And good morning, everybody. My name is Christina Nolan. I'm the U.S. Attorney for Vermont. The U.S. Attorney's Office in Vermont is part of the Department of Justice, but my offices where Jules and I work are right here in Burlington, Vermont. We enforce federal laws in the state of Vermont. So that means not only prosecuting criminal cases, violations of federal criminal law, but also enforcing federal civil law. And so we will prosecute civil cases such as fraud cases, but also very importantly for today's discussion, we will file civil cases under federal civil rights laws as well.
Thank you. We also have Erica Johnson from Vermont Legal Aid joining us. Erica, could you introduce yourself and tell us about what you do at Vermont Legal Aid?
Thanks, Annalee. Hi, my name is Erica Johnson, and I am a staff attorney in the Housing Discrimination Law Project of Vermont Legal Aid. Vermont Legal Aid is a statewide legal services organization. We have 5 different offices around the state, and I work out of the Burlington office, but I represent people who live anywhere in Vermont. And like DOJ, we represent Vermonters who have been discriminated against in their housing in violation of fair housing laws. But one difference between VLA and DOJ is that in addition to violations of federal fair housing law, VLA also takes cases with violations of state fair housing law.
Erica, can you give us an overview of the state and federal fair housing law?
Sure. So there are 2 types of fair housing laws that apply in the state of Vermont. There's federal fair housing law and state fair housing law. And for the most part, these laws have a lot of similarities. Both federal and state fair housing law prohibit discrimination based on race, family status like having kids, disability, and sex, including gender identity and sexual orientation. But Vermont also has some special protections that only apply here in Vermont. And that means that some behavior is legal under Vermont state law, even if it doesn't violate federal law.
And can you explain for us what you mean when you say someone can discriminate against someone in housing?
Well, a person who's in control of someone's housing discriminates against someone with a protected characteristic when they treat them differently than they treat others who don't share that characteristic. So some examples of this would be renting to a childless couple because they don't have kids, but not a family with kids, or a homeowner who sells to a white person, but not to a Black person.
And who can violate these laws?
Nearly anyone who has the power to make housing more or less available to someone can violate the law. This includes people like landlords, housing authorities, real estate agencies, municipalities, banks, and homeowners insurance companies. And in some cases, it can include people like maintenance workers or security guards as well.
And what are the kinds of housing activities that the fair housing protections apply to?
Well, the fair housing protections are intended to be very broad and protect as many people and situations as possible. So they can apply to pretty much any act related to housing. These could include selling and buying housing, renting, and even securing housing loans like mortgages.
What kind of housing does this apply to?
Because it's very broad, it applies to most housing. And here, housing is a dwelling. So these are buildings like houses, apartments, condominiums, dorm rooms, long-term treatment facilities, recovery homes, and shelters. There are a few exceptions, though, and a common exception is if a person is renting a room in their own home, the same fair housing protections might not apply there.
Thank you for that overview. Today, we're going to be discussing how both the Department of Justice and Vermont Legal Aid enforce the federal, state, and fair housing laws. Jules, could you start by telling us generally about the federal fair housing laws?
Yeah, absolutely. So the federal fair housing laws are very similar to the housing laws that Erica explained. Our office actually enforces all sorts of civil rights laws, those related to education, those related to employment. But obviously today we're going to focus on our fair housing law, which is just incredibly similar to what Erica described. So generally, if you think you might have been discriminated against under kind of the rubric that Erica laid out, you may have been discriminated against under federal law as well.
And when do the federal laws apply in Vermont instead of the state laws?
So this is a really common question and a common area of confusion. I think of federal and state laws as like two overlapping spider webs here. Some behavior might get caught in the state spider web, some behavior might get caught in the federal spider web, and some behavior that's totally legal is not going to get caught in either spider web, of course. But like looking at two spider webs from the outside, it's really tricky to see what's going to get caught in one versus the other. So we don't recommend at all that people try to figure this out by themselves. We just recommend that if you believe that you've been discriminated against, report it to someone. And organizations like our office and like Vermont Legal Aid can talk to each other and can help you figure out what direction to move in.
Great. So how is the Federal Fair Housing Act enforced?
So if someone believes they've been discriminated against in the ways that Erica described earlier, you have three options under federal law, and I'll go through them. The first is filing a complaint with the Agency of Housing and Urban Development, called HUD, and we actually always recommend that people take this first step because no matter which way you want to go, filing a HUD complaint can give you options by stopping a clock that's ticking once you've been discriminated. So you have to file a complaint with HUD within 1 year of when you were discriminated against. And so you can do that by going to hud.gov, HUD.gov, and you explain what happened, and HUD will actually assign an investigator to investigate what happened to you. And if they find cause to believe that discrimination happened, they will bring you and the person who discriminated together to potentially mediate some sort of resolution. And if you can't do that, they will even assign a DOJ attorney, someone like myself. In Vermont, it might actually even be me, to help prosecute your case in federal court. So that's a great option for people who just want to fill out a complaint form and have their case investigated and kind of be taken through a federal, we call it administrative process. But there are two other options. The second option is that you can just sue in court, like you hear about on TV. You get a lawyer, You hire one privately, you can maybe go to legal aid and get a lawyer, or you can just proceed by yourself without a lawyer, go to court, and you can sue the person for violating law. And that is always an option available to you. The final option involves our office and the Department of Justice's ability to bring what we call pattern or practice cases. And what those are is if we have reason to believe that a single person, say in the fair housing context, has discriminated against a whole bunch of different people in the same way, we've identified a pattern or practice of discrimination, and the law lets us kind of squish all of those cases together into one big case that DOJ would bring on behalf of all of the victims in court. And so that is another option. Whether or not you believe that you're the only one or not, we recommend you report it so we can investigate whether there's a pattern. And you can report discrimination that you think might be part of a pattern by calling 844-380-6178 or emailing fairhousing@usdoj.gov.
Okay, great. So those three options: filing a complaint with HUD, which their phone number is 1-800-669-9777. You can sue someone in court, or you can contact your office at the Department of Justice. Now, I know that because of the COVID-19 pandemic, your office in Vermont has been asked to help lead a nationwide initiative focusing on sexual harassment in housing. Can you tell us a little bit about that initiative?
Sure, I'm going to turn it over to Christina to take the lead on that.
Yeah, thanks. So my office is very proud to be leading this initiative to combat sexual harassment in housing. It's just very important that people know that sexual harassment in housing is sex discrimination under the Fair Housing Act, and it's not legal. And people need to know what their rights are. And with the COVID pandemic drastically increasing the number of people who cannot afford to pay their rent, there are some bad actors in control of housing, sadly, that are exploiting this housing vulnerability by sexually harassing those whose housing they control. And this was going on before the COVID pandemic. We've received reports of it happening during the COVID pandemic. And we know that people in need of housing are more vulnerable to this form of exploitation than ever before. So this initiative that the U.S. Attorney's Office in Vermont is leading to combat this form of sexual harassment, it's about bringing cases. We want to bring cases and make good cases and enforce the federal fair housing law. But it's also about outreach and raising awareness so that people know what their rights are. They know this conduct is illegal, and they know how to enforce their rights against pernicious landlords and others in control of housing.
Can you give us a quick definition of sexual harassment, Christina?
Yeah, sure. So sexual harassment, generally speaking, is unwanted or unwelcome conduct of a sexual nature. It can involve unwanted sexual advances or requests for sexual acts or sexual conduct. And again, it is a form of discrimination under the Fair Housing Act, the Federal Fair Housing Act.
Great. And what does sexual harassment in a housing case look like?
Yeah, so sexual harassment and sexual assault, of course, can come in many different forms, but the Department of Justice pattern and practice cases that we're talking about now tend to fall into two main categories. The first we sometimes refer to as quid pro quo, which just means a harassing situation in which someone in control of housing, like a landlord, explicitly or implicitly conditions a housing benefit on the performance of sex or sexual acts. The second type of case that we often see is what we call a hostile housing environment. And this is a situation where someone is subjected to sexual conduct, unwanted sexual conduct, that is either so severe or so pervasive on the part of the person in control of their housing that the person subjected to it is unable to use and enjoy their home.
And can you give us some examples of those two different types of sexual harassment?
Yeah, absolutely. I just want to, before I'll give you some examples of both types, but I just want it to be clear that this is not an exhaustive list. The examples I'm going to give you are meant to help you and others identify sexual harassment in housing, but it's not an exhaustive list. And if you ever have questions about whether something constitutes sexual harassment in housing, you should always report it. But in terms of the quid pro quo, as I call it, or the trading housing benefits for sex, or the request for someone to trade housing benefits for sex, some of the things we see in that category could be someone in control of housing commenting on your body or your looks, someone in control of housing sending suggestive messages to the person who's living there via email, text, or social media. The person could, and I'm sorry, this is the hostile, I'll start with the forms of the hostile environment. So like I said, sending suggestive text messages to your tenant, commenting on their looks or their body, exposing your genitals or your body parts. We've seen that in cases, or showing up unannounced to a tenant's unit in the hopes of seeing them undressed when they're unsuspecting. Those are all examples of conduct that could be so pervasive and hostile that it could help build a DOJ case. In terms of the quid pro quo, trading housing benefits for sex or sexual acts, we very typically see someone in control of housing requiring a person to engage in sexual acts as a condition of renting a home, purchasing a home, receiving needed repairs or maintenance to that home, getting a home loan, or getting a reduction in mortgage payments. We've seen persons in control of housing threatening eviction or other bad acts unless the person will engage in sexual acts with them. And we've seen those in control of housing, like landlords, offering reductions of rent, cost and rent, offering waiver of rent payments, or offering forgiveness for late rent payments on the condition that the person will engage in sexual acts with them. Again, those are examples of the two forms of sexual harassment in housing we tend to see, but it's not an exhaustive list. It's meant to help you identify when this conduct is occurring, but when in doubt, always report the situation.
All right, so if someone is experiencing something like that form of sexual harassment or something else that seems like it is sexual harassment to them, and they report it to your office, and you suspect that others are experiencing this too from the same landlord, let's say, what would you do next?
Yeah, the first thing we would do is we would have a DOJ lawyer like Jules start investigating. And we'd be looking to see, we'd be investigating for whether we could find a pattern of behavior, a pattern of sexual harassment by this bad actor, by interviewing as many people as we can, to determine whether we could bring a DOJ pattern and practice case based on the person in control of housing sexually harassing multiple victims. But even if we couldn't build a pattern and practice case, we would still counsel that person that reported the conduct on how they should proceed, such as by filing a complaint with HUD, as Jules talked about earlier. But it's important to know that in our experience, when one person is being targeted for sexual harassment by someone in control of housing, that person, he's usually targeting multiple people. But after we did the investigation, we would then determine whether we had a case, and then we'd have to decide what remedies we want to seek for this misconduct.
And what are some examples of the remedies that these suits can achieve, and how do you achieve them?
Yeah, so there's actually a few different remedies we can pursue. I'll give you a few examples. Again, not an exhaustive list, but some of the main examples. So we can seek restraining orders on behalf of the victims as against the bad actor in housing. We can seek injunctive relief. And what that means is you can get court orders that do things like bar the landlord or the other, or some bad actor in housing from participating in the housing market for a period of time. It can be a long period of time. You could get a court order that requires an independent and responsible property manager to take over management of the property that the bad actor has been managing. You can get an order requiring the bad actor to undergo sexual harassment training or other appropriate training. And then you can also, of course, seek money on behalf of the victims. We call them compensatory damages, compensating them for their suffering at the hands of the person who controlled their housing. Now, in deciding what remedy we would seek, that will involve a consultation between the DOJ lawyer, somebody like Jules, or another DOJ lawyer, and the victim or victims. And you know, it would be a consultation, a collaborative decision, but the wishes of the victim would weigh heavily in how we decided to proceed. One thing I want people to understand is that we will always seek a settlement with the harasser before filing a lawsuit, you know, short of going to court. And very, very often we get what we want through a pre-litigation settlement. That is, the harasser agrees to give us what we want without, and what the victim wants, without even having to go to court. Our settlements have involved recoveries of substantial sums of money on behalf of victims, and also this injunctive relief I've talked about, principally in the form of barring the landlord or the bad actor from the housing market in the future. But if we need to file a lawsuit, we would do that too if the harasser won't settle, and would do it in consultation with the victim.
Okay, thanks for walking us through that. Is there any way for people who are reporting sexual harassment to go through that process anonymously?
So you absolutely can anonymously report. If we had to file a lawsuit and we couldn't achieve a settlement short of a lawsuit, we would not include the victims' names in any documents we file in court initially. And we would do everything we could to keep a victim's name out of court. Achieving total anonymity throughout the life of a lawsuit can be difficult, but we can take steps to protect the complainant's identity from becoming public. And you should absolutely know that we would never go forward with a lawsuit if the victim was not comfortable, victim or victims were not comfortable. Even if they'd already reported the misconduct to us, we would not do that without their consent.
All right. And what are the advantages of Department of Justice being able to bring those pattern and practice cases where it's a lot of people's experiences with one bad actor combined into one lawsuit?
Yeah, so victims of sexual harassment very often feel shame, and they feel like they're all alone, particularly when they had to assent to their harasser's demands for sex. So one benefit from these pattern and practice cases is togetherness. And what I mean by that is, in our experience, it is not true that these victims are alone. Sexual harassers in housing, if they're targeting one victim, they tend to be targeting multiple victims. And also, when people come together and build a case, the victims are brought together. In our experience, that case is so much stronger when you increase the number of victims, because sexual harassment so often happens behind closed doors with no witnesses. And so a pattern and practice case that, with the togetherness of the victims, takes the dynamic from a he said, she said case to a he said, and she said, and she said, and she said, depending how many victims you have. The other advantage of togetherness is that, you know, big problems require big solutions, and they often yield big solutions. So when we bring all victims together in one lawsuit about the way they were discriminated against, we will hopefully be able to show the magnitude and the scope of the problem and get an appropriately big solution to that problem. So that's the advantage of the togetherness of the pattern and practice cases. There's another advantage I'll touch on, which is the advantage of timing. Now, when someone hires a lawyer and just sues to enforce their rights, they have to do that within 2 years of the sexual harassment occurring. If they go through the HUD process, they have to do it within 1 year of the sexual harassment occurring. But in a DOJ pattern and practice case, we have 3 years from the time that the DOJ learns about the harassment to bring that pattern and practice case. And when we're investigating how many victims to include in that case, we can include victims who had harassment predate that 3-year period. So, so essentially, you have a lot more time in a DOJ case to bring the case and build the case. There's no time limit on bringing victims in, even before that 3-year period I talked about. And so we're able to bring together victims across decades very often in our cases.
Thank you so much to Christina and Jules for walking us through the Department of Justice process for sexual harassment complaints. I want to turn it over to Erica, and can we talk a little bit about how the Housing Discrimination Law Project at Vermont Legal Aid can help with these kinds of housing cases?
Definitely. So Vermont Legal Aid provides representation at all stages of fair housing cases. Anyone who gets in touch with our office, we will give brief advice to them over the phone about their legal situation. In a lot of cases, we will negotiate with opposing parties to try to reach a settlement before filing a case, like Christina talked about with DOJ. And we will also represent people in cases in state court, in federal court, and before HUD, like Jules was mentioning, or before the Vermont Human Rights Commission.
Great. And are there any kind of income requirements that people would need to meet in order to get help from Vermont Legal Aid with housing issues like this?
No, HDLP doesn't have any income requirements, which is one of the great things about our office. Anyone who has a fair housing issue in the state of Vermont can give us a call and we can give them some help.
Wonderful. And why are we doing so much talking about fair housing during COVID?
Well, we know that nationally, and we have no reason to believe that this isn't the case in Vermont as well, people who are in protected categories in fair housing are the same people whose housing is the most impacted by COVID across the board. And this is especially true for people of color and people with disabilities. So today I want to very quickly touch on 3 different types of discrimination that often come up when people are applying for homes, like public assistance, family status, and disability. Now, I want to be clear that housing discrimination can happen at any time. It can even happen after someone has moved in. In fact, that it happens a lot of the time in that situation, but application questions are some of the more common questions that we get. So I wanted to take a few minutes to talk about them today.
Great. Let's start with the first one. What is discrimination based off of receiving public assistance?
So this is one of the state law protections that applies in the state of Vermont. And basically it's treating someone differently because they are using a form of public assistance, like a voucher. It doesn't have to be a voucher, but that's the most common situation that we see.
And what kinds of things are public assistance benefits that would count for this?
So we see a few common situations. One is landlords who aren't aware of the law will sometimes advertise a property as no voucher or no Section 8, and that is firmly a violation of Vermont state law. And it's also a violation for a landlord to tell an applicant that they aren't sure whether they want to rent to someone with a voucher because they've had issues in the past with people with vouchers. And that's the case even if the same landlord ends up renting to someone with a voucher, because making that kind of statement that could discourage someone with a voucher from seeking an apartment is a discriminatory statement under the state law.
What kinds of things would not qualify as discrimination based on receiving public assistance?
So we get a couple common questions that, it's less clear. And one of the ones that it doesn't quite violate state law is a landlord is allowed to charge a market rent for a property that may be higher than a set payment standard for a voucher. So if a voucher can't cover the monthly rent for a particular property, the landlord isn't required to lower that rent. That's not a requirement that exists in state law. There's another one though that's a little trickier, so we'd recommend that you call VLA if you're in this situation. If a landlord is expressing that they don't want to rent to someone with a voucher because they don't want to participate in some of the requirements of the program, so to fill out additional paperwork or to go through some extra, say, Section 8 inspections, then that's a really fact-specific situation. So again, if that's happening, we would recommend that you call Vermont Legal Aid or use our online intake form for a specific advice on your case.
And the Vermont Legal Aid phone number is 1-800-889-2047, or our website, again, is vtlawhelp.org. So we talked about the discrimination based on receiving public assistance. Let's talk about the second one you mentioned, the family status discrimination. What does that mean?
Sure. So that is treating someone differently because they intend to live somewhere with one or more minor kids. And something that's important to know is that this doesn't just protect parents. It also protects people who are pregnant, people who have temporary or permanent legal custody of a minor, including people who are in the process of getting that custody, and people like foster parents as well.
Okay, great. And what kinds of discrimination against parents or people who might become parents is illegal under fair housing law?
So just a few quick examples, but as Christina mentioned earlier, not an exhaustive list. So one issue that violates the law is telling a housing applicant that the landlord doesn't rent to people with kids because they just think kids are too messy and too noisy, and they don't want to have people like that living in their apartment. That's a clear violation. Another one would be renting to a family with kids, but charging them a higher rent for having kids or a higher security deposit. That's another thing that is not okay under the fair housing laws. And then a pretty common one we see is a landlord will engage in what's called steering. So they'll say to a family with kids, oh, you can rent this property over here, but we're not going to allow you to apply to this property over here because it's really just too small for kids to live there, or the neighbors are sensitive to kid noise, things like that. Now this can be a fact-specific situation too, because landlords are allowed to set reasonable occupancy standards. So if you have any questions about this one, another situation where you should call our office and we will talk to you about it.
All right, thank you. What sort of things are landlords able to do that wouldn't count as discrimination based on family status?
Well, a common one is that landlords are always able to screen out applicants who have prior lease violations. And this is true even if those prior lease violations were caused by children. So if a tenant is applying for an apartment and the landlord checks their references and they learn that the tenant's kids who will be living with them in the apartment have a history of causing property damage that is very significant, or a history of really significant noise complaints that rise to the level of lease violations, then the landlord can screen out that tenant and decide not to go further in the application process if it's based on those specific kids. It can't be based on a generalization of all kids, but if it's those specific kids, then that's something that would be permitted.
All right, and let's go ahead and talk about the third kind of discrimination you wanted to touch on today, disability discrimination. What does that look like?
Sure, so this is something that's a little different than the other types of discrimination we've talked about today, because people with disabilities have some additional rights under fair housing law. So like members of other protected classes, people with disabilities have the right not to be treated differently in their housing because of their disability. But they also have the right to something called a reasonable accommodation. And very quickly, a reasonable accommodation is a change to a rule, policy, or practice that may be necessary to give a person with a disability equal enjoyment of their housing. So common examples of this are a person with mobility challenges may need a wheelchair ramp, or someone who has, say, anxiety may need an emotional support animal. And COVID is making some types of reasonable accommodation requests come up more often than usual. So we wanted to briefly touch on a common example of that today.
Okay, great. And we actually do have an audience question about emotional support animals. But before we go into that question, can you just give us a quick explanation of what an emotional support animal is?
Sure. So an emotional support animal is an animal that is used to treat some symptoms of mental health disorders. So these can be things like anxiety, PTSD, depression, or other things in that category. And so something that's important to consider under fair housing law is that these animals they're not considered pets if there is a medical need for an emotional support animal in housing, then it's a reasonable accommodation under federal and state fair housing law. And assuming that the situation is reasonable and that the animal can live well within the apartment, isn't a danger to other people, isn't causing damage to the property, then that tenant has a right to, or whomever has a right to live in their housing with that emotional support animal.
Okay, thanks for that quick explanation. So our audience question is wondering if there is a way for, if someone in Vermont has a letter from their healthcare provider that their animal is an emotional support animal and asking for a reasonable accommodation because of their disability, how can someone in that situation go about proving that they've been denied housing based on their emotional support animal? It sounds like this person has had some questions about it maybe being a gray area. Are there steps they should take to start that process of looking into that?
Yeah, definitely. So the first step is to make the reasonable accommodation request to, in this case, it sounds like it's a landlord. So if the landlord has a no pets policy, we recommend that reasonable accommodation requests be submitted in writing so that everyone has a clear record of what's being said, what's being asked for. And we have some sample letters for making reasonable accommodation requests on our website, vtlawhelp.org. But there's no magic language you have to use. What you have to communicate is, I am a person with a disability. I need this accommodation to have equal enjoyment of my housing, and the accommodation that I need is an emotional support animal. So that would be a change to the no pets policy that allows this tenant to live in the unit with the animal. And we also recommend that the letter gives, let's just say it's a landlord, that the letter gives the landlord a date to respond. Please let me know your decision by this date. And it sounds like, in this example, there's a letter from the healthcare provider saying that this emotional support animal is needed. If you have that, you can go ahead and attach that to the reasonable accommodation request. It's a good thing to have, but you don't need it when you're making that initial request. And the housing provider is required to reply to a reasonable accommodation request. So if you don't hear anything from the provider within a reasonable amount of time, let's say that you gave them, say, like 14 days to respond, and 14 days go by and you haven't heard a response, or you've heard a no, then that's a situation in which you could go ahead and call Vermont Legal Aid to find out the next steps, because if the accommodation that you're asking for is reasonable, a denial of that request is a violation of federal and state fair housing laws.
All right, and if this person wants to give us a call for more about their specific situation, the phone number again is 1-800-889-2047, or you can go on our website, which is vtlawhelp.org. We touched a little bit about the kind of reasonable accommodation that an emotional support animal would be. Can we talk a little bit about some examples of reasonable accommodation requests we're hearing a lot about, specifically because of COVID?
Absolutely. So one question that we're getting that is really common during COVID is questions from people who are in high risk categories for COVID, usually people who are renting. So if a tenant has something like respiratory disorder like asthma or any condition that may make them immunocompromised, they may be in a higher risk category for COVID, or maybe someone in their family who they live with meets that description. And we've heard from people, are there steps that I can take to keep my family, safer from COVID and keep fewer people from coming into my apartment? So in situations like that, we've been recommending that people can make a reasonable accommodation request of their landlord. And that request would be something like, I have a disability that puts me in a higher risk category for COVID. I'm asking that any routine inspections or maintenance of the apartment be put on hold for the time being, so that they can limit the number of people that are coming into their home, their exposure to any germs that might be being carried into the home. And that's so that's a more common request that we are getting. And we always want to make sure to explain that doesn't change, even if the RA request is granted, that wouldn't change the landlord's ability to come into a unit in an emergency situation. So if there's a situation where there's an imminent danger or risk of damage or significant harm to property or to a person who's there, then the landlord can still, that the RA request wouldn't stop a landlord from being able to address that issue, quickly and efficiently. But with the RA request in place, that should be, people are within their rights to ask their landlords to kind of put on hold the stuff that doesn't need to be done today, isn't urgent, for the time being.
All right, so there are ways to ask for reasonable accommodations, especially now because of COVID. Can you walk us through, and we did touch on this a little briefly with the context of emotional support animals, what's the general process that someone can go through when they are asking for a reasonable accommodation, even if it's for something like asking your landlord to hold off on those inspections because of your risks of getting COVID?
Sure. So we recommend that you put the request in writing, and you can just say, like I mentioned, there's no magic words to ask for a reasonable accommodation, and your reasonable accommodation request is still legally valid, even if you don't put it in writing. But putting it in writing is, a handy thing to have, because it creates a record of what happened and when, and if you need to at some point get advice from a lawyer or get a lawyer involved down the road, then that makes your claim a lot stronger and a lot simpler. And the request doesn't have to be long. It doesn't have to be detailed. It doesn't even necessarily have to disclose your exact disability. So the important thing is that when you make the request, you make sure that there is a clear link between your disability and what you're asking for. So to go back to the COVID example, you might say something like, I have a disability that puts me in a high risk category for COVID. And so I'm asking for a change to the regular inspection and maintenance schedule so that those things are put on hold and I am less exposed to COVID. So you can see there's a clear link there between the need to have less exposure to people so that you are, that your high risk category of COVID is less likely to make you sick, and the request that you're making. So that's an example of that. And we also recommend, just as best practice, it's not necessary, but to move the process along, we recommend that you include in your request a date, a reasonable timeline for the housing provider to respond to your request. And that kind of sets a deadline for you as well, to know that if you haven't heard from the housing provider by that date, then you can consider, you might be able to consider it a denial and move forward. Obviously, if you've heard from the housing provider and the housing provider is trying to work with you to get your needs met, then that date's not set in stone. That's not a firm, well, we've hit that date, so discussions are over. But it can be a nice thing to give people a milestone for when to consider the RA request denied if the landlord hasn't responded, and when to give our offices a call.
Okay, thank you for that general walkthrough of asking for a reasonable accommodation. And again, if people need more information or sample letters that they can use, there's help on our website. vtlawhelp.org. I'm seeing that we do have another question coming in from our audience about emotional support animals. This person is wondering what happens if the emotional support animal you have is a pit bull. Can you give us any information about that?
This is an excellent question. So one thing to consider about emotional support animals is, like any reasonable accommodation request, they have to be reasonable. So, your emotional support animal can be any breed of dog. What's important is that your specific dog is not, can't be considered a threat to, someone on the property, or, causing damage to the property. So if your specific dog, no matter what their breed, is, kind of aggressively barking at other tenants in the building, or like lunging or things like that, that's an early sign that, okay, we could have some trouble with this down the road. And that's a time to maybe get a professional trainer involved, or, or do some behavioral intervention there. Because folks aren't entitled to a specific emotional support animal. They're just entitled to, have one, and they're not entitled to one that can be a threat to other people. Now, having said that, there are many wonderful, non-aggressive, perfectly safe pit bulls in the world, and there are many situations where they're not threatening. And this is a common misconception we hear from landlords, especially, some landlords, they have insurance policies that they believe prohibit certain breeds. And if that's the situation that you're in, we'd recommend that you give Vermont Legal Aid a call, because we've seen, we've had situations where landlords aren't 100% correct about what their insurance policy requires. And we've also seen situations where what the insurance policy required doesn't pass muster under federal and state fair housing law, and so shouldn't be enforceable in this context. So the short answer is, as long as your pit bull isn't a risk to the unit that you're living in or to people there, then you are free to have a pit bull as an emotional support animal.
Okay, thank you for that. And we also did get a follow-up question right as you were saying it, the question about if insurance companies for the landlord do not allow pit bulls. And it sounds like someone who's heard this from their landlord would want to give us a call for more information about that. That's something that could be, discrimination. So you could give us a call. The number is 1-800-889-2047. And you brought up a point about, if there is a need for an animal to, get some kind of training. Just wondering, is there any specific requirement for an animal to get special training to become an emotional support animal? Any kind of certification or something like that they would need?
That's another excellent question. And this is a difference between an emotional support animal and a service animal. But emotional support animals don't require any special training or certifications, as long as you have a medical need for the emotional support animal, and as long as that can be backed up by a reliable third party, and ideally a healthcare provider, then that's all you need to access that right. And like we kind of alluded to before, we strongly recommend that you have, especially if it's a dog, we strongly recommend that you go through the normal dog training procedures so that your dog is well socialized and not it isn't difficult to live with if you're in like a multifamily situation, for example. But there's no magic certification. They don't have to get a little ribbon that you can print online. As long as you have that medical need and can show the connection between your mental health symptoms, primarily mental health symptoms, and your emotional support animal, then you are good to go.
Great. Are there any kind of rules about how many emotional support animals someone can have at one time?
So this is where it gets a little tricky. There are no hard and fast rules about how many, but this is where we go back to our reasonableness inquiry, right? So this is going to be a pretty fact-specific situation. If you have let's say you're renting a very large house in the middle of the country with a very large yard, and you have more than one emotional support animal, and they each, they each do different things for you, or they each treat different symptoms of your disabilities or different disabilities, then that's a situation where you would say, yeah, that sounds reasonable enough. There's plenty of room for these animals to like get exercise and things like that. But if you're living in a small apartment and you're trying to live there with like 4 to 6 animals, and there's not really enough room for them to go around without scratching things, and maybe they're kind of like setting each other off and making noise in the middle of the night, like that's a situation where we think, okay, maybe we have some questions about the reasonableness of that. So the short answer is that there's no special rule, there's no magic number, but this is one of those situations where you kind of look at your whole situation and see, does this make sense for where I am, and could I explain to someone else why this situation makes sense?
All right, thanks for talking us through that. Because application season, when a lot of people are trying to find a new apartment is upon us, like you said, can you talk to us a little bit about what happens if you have an emotional support animal already and you're applying for a new apartment, and the application lists if you have pets? Do you list your emotional support animals on the application? Do we have any recommendations about how to do that?
We do have recommendations about that. And I just want to say from the outset that this is a really tricky situation to navigate. So one thing that we referred to before is that, under fair housing law, an emotional support animal is not a pet. So you are not required to list your emotional support animal. We would argue on an application that asks, do you have any pets? Because you don't. What you have is a reasonable accommodation animal. Like, it wouldn't necessarily be an accommodation if there's not a no pets policy, but you have an animal that you are likely entitled to live with as a treatment of your disabilities, just like therapy or medication could be treatments of symptoms of those disabilities. So we say that if you are wondering if the landlord is trying to use that as a discriminatory question, you're not required to list it. And if you decide you don't want to list it, we recommend that you could sign a lease, and then if there's a no pets policy in the lease, you could then, once everything's set in stone, you could then ask for a reasonable accommodation to make a change to that no pets policy so that you can have your animal live there. And the advantages of that are, maybe the landlord's a little annoyed at first, but you sign a lease, you move your animal in, a year later, your animal has behaved perfectly, there are no problems, you're a great tenant, the landlord says, okay, maybe this is okay, and renews the lease for another year. But there's not a perfect answer for everyone, because you are taking the risk that maybe the landlord feels like you weren't being totally upfront with them at the beginning, even though you're not legally required to. So we don't make that recommendation across the board for everyone. What we want to emphasize is that our position is that you are not legally required to list your emotional support animal in the pet section of a lease, and that it's really up to you to make your own personal decision about how, feeling out how you feel about how this landlord would respond in that situation.
All right, thank you for walking us through that. We are approaching the end of our time here together, but I do want to bring up just a quick point, because we have talking so much about the vulnerabilities that people have because of COVID. Is there any way that people can get help if they're behind on their rent or their mortgage payments because of COVID, and they're really vulnerable in their housing because of that?
Yes, so this is really exciting information. There is assistance available for both past due rent and for mortgage payments. And for the past due rent, you can access this assistance if you are a tenant or if you are a landlord. So we recommend that you follow up on our website, vtlawhelp.org. And once you get to vtlawhelp.org. There's a green banner right at the top with the information about COVID. It's a great resource for all kinds of questions about COVID and housing and other benefits, but you can find all the information you need there for rental assistance and mortgage assistance.
All right, so if people have questions about being behind on their rent or because of COVID, check out our website, vtlawhelp.org, for information about the assistance programs. As we're beginning to wrap up, I want to bring Jules and Christina back in. Can you just remind us how people can report their experiences with sexual harassment and housing to the Department of Justice and your office?
Hi, yeah, happy to. So the Department of Justice has set up a hotline especially for reports of sexual harassment in housing, because we understand it's such an important and specific issue. So that number again is 844-380-6178. And that's staffed by paralegals or attorneys who are trained in this area and are really ready to take your complaints and answer your questions. You can also email fairhousing at usdoj.gov. And finally, if you want to get in touch with our office directly, where we understand some folks want to talk to someone in Vermont, someone who's local, you can absolutely do that. We have a complaint form on our website. Our website is justice.gov/USAOV-VT. It's like a hyphen or a dash. And you'll see right on the right-hand side, there's a link that says Civil Rights Complaint Form. And you can fill that out with fair housing complaints, sexual harassment and housing complaints, or really any civil rights issue you're having. And that will come straight to me. And our office responds to every single one of the complaint forms that we get. And it's a great way for you to get in touch with our office here in Vermont.
Wonderful. Thank you so much for walking us through that. And you had also mentioned for us earlier that regardless of if people want to contact the Department of Justice, a good option is filing a complaint with HUD, because you only have a year to do that. Can you walk us through the contact information for HUD one more time, just in case people want to do that too?
Sure thing. Yep, HUD.gov, so HUD.gov is their website. They also have a phone number, 800-669-9777. And HUD is great. It's meant to be really user-friendly. You don't have to be a lawyer. You don't even have to ever spoken to a lawyer. They have people who will just walk you through the process of how to file a complaint.
Wonderful. Thank you, Jules. And Erica, can you walk us through the steps to get in touch with Vermont Legal Aid if people have questions about their individual situation?
Yes, definitely. So in the time of COVID, we have two ways of getting in touch. The first is by phone, and you also have the option to get in touch with us online. If you want to reach us by phone, you can call our intake line. That number is 800-889-2047, and leave us a voicemail with a few sentences about your legal question, and someone will return your call, one of our trained advocates or our attorneys. And if it's an emergency, please do let us know in the voicemail so that we can give you a call back ASAP. Or if you'd like to reach us online, you can fill out an intake form at our website. Again, that's vtlawhelp.org. The intake form is vtlawhelp.org/VLH-intake. And if you are a case manager or a social worker or a provider who's working with a client who could use some legal assistance from Vermont Legal Aid, you can use that same link to fill out a partner referral form. And one of the great things about that option is that if you have a meeting coming up with your client, then you can let us know, and so we can make sure to give you a call back when you're meeting with that client and everyone's in the room.
Awesome. And what will happen if you have a question about, sexual harassment and on behalf of a landlord, and you reach out to Vermont Legal Aid? Is there a way that we can refer folks over to Department of Justice, or vice versa, if Department of Justice hears about something that Vermont Legal Aid would want to take care of? Do you folks work together at all?
Yes, absolutely. So the thing we want to emphasize is you can call either of us and we will make sure to get you to the right folks.
Wonderful. And that about wraps up our time here together. I want to thank Erica Johnson from Vermont Legal Aid for sharing so much of your expertise with us today as part of our regular town halls. And a big extra shout out to Jules and Christina, our very special guests here today from the Department of Justice, U.S. Attorney's Office right here in Vermont. Thank you to everyone who attended. If you have any questions, again, feel free to head over to our website, vtlawhelp.org, or give us a call at 1-800-889-2047. If you had to join us partway through and you want to go back and watch any of this town hall today, the recording of it will be on our Facebook page and our website, and feel free to go back and watch if you need a refresher at any point. Thank you so much for joining our town hall, and we really appreciate all of your great audience questions today, and we look forward to more town halls in the future. Thanks to Jules, Christina, and Erica one more time.
Thank you.
Thank you all.